Okay. Madam Chair, we can begin.
Great, thank you. Thank you, everyone, and our apologies for starting a few minutes late. The Commission on State Mandates will come to order at 10:08 a.m. Welcome to the webinar. Statutes of 2023, Chapter 196, amended the Bagley-Keene Open Meeting Act to extend until the end of this year, December 31st, 2023, the authority to hold public meetings through teleconferencing. The Commission continues its commitment to ensure that its public meetings are accessible to the public and that the public has the opportunity to observe the meeting and to participate by providing written and verbal comment on Commission matters. Please note that the materials for today's meeting, including the notice, agenda, and witness list, are all available on our website, www.csm, Commission on State Mandate.ca.gov. Again, csm.ca.gov under the Hearings tab. Also, please note that in the event we experience technical difficulties or the meeting is bumped offline, we will restart and allow time for people to rejoin between recommencing the meeting. And please join me in welcoming, although I don't know if she's on yet, Regina Evans will be joining us from the Controller's Office. Thrilled that she's here. I've gotten to work with her on a few other boards, and when she comes, we will thank her for joining and welcome her. And with that, Ms. Halsey, will you take the roll, please?
Sure, and I'd also like to ask the parties and witnesses to please turn off their cameras and mute their microphones until their matter is called. And also to let you know that Member Nash notified the Commission staff that she will not be able to attend today's meeting. Mr. Adams.
Here.
Ms. Cohen. Ms. Evans. Ms. Holman.
Here.
Ms. Miller.
Here.
Ms. Olson.
Present.
Mr. Walker.
Here.
We have a quorum and will update us when anyone else joins. So our next item of business are the minutes from May 26, 2023. Is there any public comment? Are there any objections or corrections to the minutes?
Move adoption.
Thank you, Ms. Olson. Thank
Second.
you, Mr. Adams. It's been moved and seconded. May we please call the roll?
Sure. Mr. Adams.
Aye.
Ms. Evans. Ms. Holman.
Aye.
Ms. Miller.
Aye.
Ms. Olson.
Aye.
Mr. Walker.
Aye.
Right, the minutes are approved and we will hold that roll open in the event anyone wants to add on. We'll now move to public comment, Ms. Halsey.
And now we will take up public comment for matters not on the agenda. Please note that the Commission may not take action on items not on the agenda. However, it may schedule issues raised by the public for consideration at future meetings. We invite the public to comment on matters that are on the agenda as they are taken up.
Thank you. Is there any public comment? Feel free to raise your Zoom hand. I don't see any public comment. So we will move to the next item, please, Ms. Halsey, for swearing in.
Will the parties and witnesses for items 3, 5, 6, and 7 please turn on their videos and unmute their microphones? And please rise and state their names for the record.
David Burhan, Burhenn. I'm here to speak on items 3 and briefly on item 7.
Thank you.
Chris Hill, Department of Finance, for items 5 and 6.
Thank you.
Donna Furby, Department of Finance, for items 3 and 7.
Also Marilyn Munoz for Department of Finance for item 3.
Thank you.
Lucia Gonzalez with the Office of County Counsel, Los Angeles County, on item 5.
Thank you,
Fernando
Ms. Gonzalez.
Lemus, Fernando Lemus, Department of the Auditor Controller, County of Los Angeles, item 5.
Dylan Ford from the Office of County Counsel on item 5.
Thank you. And is that everybody?
Catherine Hagan for the Water Boards on item 7, and Jennifer Fordyce
as well. Hello, I'm Jennifer Fordyce. We had some technical difficulties, so sorry about running a little bit late.
Oh, no
No
worries.
worries.
You're right on time. Okay. Do you solemnly swear or affirm that the testimony which you're about to give is true and correct based on your personal knowledge, information, or belief?
I do.
I
I
do.
do.
I do.
Thank you. Please be seated. Item 2 is reserved for appeals of executive director decisions, and there are no appeals to consider for this hearing. Next is item 3. Senior Commission Counsel Juliana Murr will please turn on her video and unmute her microphone and present a proposed decision on order number R9 2010-0016, adopted by the San Diego Regional Water Quality Control Board, 11 TC03. At this time, we invite the parties and witnesses for item 3 to please turn on their video and unmute their microphones.
Good morning.
Good morning. How are you, Ms. Moore? Nice to see you.
Very nice to see you, Madam Chair, and nice to see you all, members. This test claim alleges reimbursable costs mandated by the state to comply with the 2010 test claim permit issued by the San Diego Regional Water Quality Control Board, which removes some non-stormwater discharge exemptions, identifies action levels for some pollutants, requires that low-impact development and hydromodification prevention be considered for new and redevelopment projects and as part of a retrofitting program, requires a database to track and inventory post-construction BMPs and BMP maintenance, requires implementation of active-passive sediment treatment at construction sites, requires erosion and sediment controls after construction and during maintenance of unpaved roads, increases the scope of commercial and industrial inspections, establishes the watershed water quality work plan, expands annual reporting requirements, establishes special studies, and requires that the claimants effectively prohibit non-stormwater discharges and prevent runoff discharges from the MS4 from causing or contributing to a violation of water quality standards. Staff finds that many activities alleged in the test claim are not new, but were required by the prior permit. Staff further finds that the requirements regarding municipal projects are not mandated by the state and are not unique to government, and therefore do not mandate a new program or high level of service. In addition, consistent with 2 recent Court of Appeal decisions, staff finds that the claimants have the authority to impose regulatory fees for all new mandated activities relating to low-impact development, hydromodification, retrofitting, BMP maintenance tracking, and active-passive sediment treatment, which are sufficient as a matter of law to cover the costs, and thus there are no costs mandated by the state for these activities pursuant to Government Code Section 17556D. Staff recommends that the Commission partially approve the test claim for the new mandated requirements identified in the proposed decision addressing stormwater action levels, the watershed work plan, annual reporting, and special studies from November 10, 2010 through December 31, 2017 only. Finally, staff finds that there is no evidence in the record that the Riverside County Flood and Water Conservation District was forced to spend its proceeds of taxes and therefore does not have any costs mandated by the state. Staff recommends that the Commission adopt the proposed decision to partially approve the test claim and authorize staff to make any technical or non-substantive changes to the decision following the hearing.
Oh my gosh, it's 2023. I should know how to unmute. Thank you very much, Ms. Gammer. I really appreciate that. That was very helpful. We're now going to move to the parties and witnesses. And if you could please state your names for the record. We'll start with Mr. Burren for the claimants, if you'd like to begin, and please correct my pronunciation of your name, and I apologize.
I've lived for a long time, Chair Miller, with that name being mispronounced. So
Oh, tell me how so I don't get it wrong again.
I used to say it's like a cold chicken, Burhen. It's of course having a German name, but I have it. Thank you.
I'm not going to forget that again, Mr. Burhen.
Before I hope not. Thank you, Chair Miller, and good morning, members of the Commission. My name is David Burhen. I'm with the firm of Burhen & Guest, and we are the claim representative for the claimants in this matter, which are the Riverside County Flood Control and Water Conservation District, County of Riverside, and the cities of Murrieta, Temecula, and Wildomar. I want to first thank staff for the hard work in putting out a 475-page proposed decision. And we want to recognize this as a massive effort. And even though we obviously don't agree with everything in it, we certainly appreciate the hard work that went into it. I would also like to indicate that we incorporate all of our previous written comments, and by this presentation are not waiving any of those comments. I have two main comments this morning which cover several items in the proposed decision. The first relates to municipal projects, which you just mentioned. The proposed decision would deny reimbursements where claimants must comply with test claim permit requirements that apply to municipal projects on the ground that they voluntarily undertook those projects, and thus they were not mandated. This applies to several items in the proposed decision, including the retrofitting requirements in section F3D, a BMP database requirement in section F1F, unpaved road requirements in section F1I and F3A10, and reporting on municipal projects in section K3. Claimants submit that when a project has been constructed or accepted by a local agency, even if that construction or acceptance was in some sense discretionary, permit requirements which apply to those projects downstream of those acts should be treated as mandates. By downstream, I mean requirements that are separate in time or subject matter from the original action of the local agency. The proposed decision does not accept our comments on this point, citing two main cases known as Curran High School District and City of Merced. These cases, however, involve direct relationships between some voluntary action of a local agency and a resulting non-mandated cost. For example, in Curran High School District, the district voluntarily entered into a statutory program providing for state grant aid, and then the legislature amended that statute to add notice and agenda requirements, which involved extra cost. The City of Merced case involved the city's decision to invoke eminent domain proceedings and then having to pay more to the property owner because the statutory provision required that loss of goodwill must also be compensated. In those cases, there was a direct link between the municipality's discretionary act and the financial consequences of that act. In this claim, the consequences, which are increased costs from stormwater permit requirements, are considerably distant from the decision by the municipality to build or acquire a project. For example, in the case of unpaved roads, a municipality must formally accept a road for it to be included within the municipality's road system. But that acceptance may have occurred several decades ago. The county of Riverside, for example, has been in existence since 1893. The acceptance of a road may have been discretionary, but we can be assured that the County Board of Supervisors in 1920 or 1930 or even 1980 had no conception of a municipal separate storm sewer system permit that would decades later govern how the county maintained those roads. As another example, when a permittee is required to report to the water board or include in a database information on existing municipal stormwater projects, those projects have been completed. There is no functional difference between that completed municipal project and a private project. Claimants respectfully submit that when requirements are imposed on permittees concerning such completed municipal projects, there is no act of discretion that waives subvention. This was a concern of the California Supreme Court in the San Diego Unified case that was cited in our comments. The court there suggested that many existing mandate cases could in fact be overturned at the time because the local agency had made a discretionary decision, which triggered the mandate. And the example they gave was the famous Carmel Valley case, where subvention was approved for the costs of additional firefighter safety equipment. The court mused whether that case and others finding subvention could stand under very strict application of the City of Merced case. But even if municipality incurs costs through a discretionary decision to undertake some project, subvention still may be required if those costs are practically compelled to the municipality facing certain and severe consequences if they did not act. This concept of practical compulsion applies directly to the maintenance of unpaved roads at issue in this test claim. In our written comments, claimants cited state law, specifically Government Code Section 835 and related statutes, which provide that a municipality is liable for dangerous conditions on its property, including roads. Courts have held that municipalities which fail to adequately maintain their roads are liable to injured parties. Thus, to avoid these consequences, claimants must maintain unpaved roads, and in doing so, are subject to the requirements and increased costs set forth in the test claim permit. Because of this practical compulsion, subvention should not be barred. My next final comment relates to the notion of regulatory fees, and this was again alluded to by Ms. Nur. Claimants agree, and it's settled law, that if a local agency has the authority to recover mandated costs from a private party through regulatory fees, such as inspection fees, those costs are not recoverable in a test claim. However, in this test claim, claimants have identified specific mandates for which they lack such authority. An example are costs associated with inventorying and evaluating existing development areas for potential water quality retrofitting. That's in section F3D of the test claim permit. Claimants are required to identify and inventory those existing areas of development that are candidates for retrofitting. They then must evaluate and rank those areas to prioritize retrofitting and incorporate those findings into work plans. These requirements are discussed on pages 207 to 210 of the proposed decision. Is there some entity that can be charged for the cost of those requirements? On page 44, the proposed decision states that the fact that claimants already issued the original permits on that existing development, quote, does not defeat their authority to impose a fee to cover the cost of these activities, close quote. But impose on whom? Certainly not the original developers, since the projects are completed and any development permits have expired, and the properties in fact may have been sold to one or more new owners. Is it future developers? On page 445, the proposed decision states that such costs are for services, quote, provided directly to developers and property owners, close quote, in the form of LID and hydro modification plans to assist in their retrofitting projects. But with respect, that's not correct with respect to the surveying, inventorying, evaluating that I discussed. Providing LID and hydro modification plans clearly benefit developers of a retrofit project. Inventorying and evaluating existing development for retrofitting potential does not. No developer benefits from such a general review. No planning documents to assist a developer are produced. The required work does identify, for the benefit of the municipality, what areas are best for retrofitting and how watershed planning can proceed from that knowledge. Then, if a developer decides to retrofit an existing property identified in the review, courts have ruled that the cost that municipalities incur to develop LID and hydro modification planning documents can be recovered from that developer. But here, the retrofit identification tasks are not for that purpose. They're for the purpose of improving water quality generally by identifying areas that would benefit from retrofitting. Those inventory and evaluation tasks do no more than identify those general areas. That effort, like the placement of trash receptacles in the LA County stormwater permit, benefit persons and water quality generally, and thus is a property-related cost subject to the requirements of 218. And since there is no reasonable relationship to any benefit provided to a developer from these activities, any development fee imposed for those services would be in violation of the Constitution. I would also add that the requirement in test claim permit section F1D4A provides no benefit to any developer, but merely requires claimants to review local codes, policies, ordinances, etc., to identify and remove barriers to LID implementation. and to include that review in a JRMP document. This is an effort which, again, has nothing to do with any specific project requiring LID efforts, but is an effort to identify and remove obstacles on a community-wide basis to imposition of low-impact development. Thank you very much for your attention to these comments. I would be happy to answer any questions that commissioners may have.
Thank you very much, Mr. Burhan. Next, we'll go to Ms. Farby from the Department of Finance, please.
Hi, thank you. I'm going to defer to my colleague Marilyn Munoz, who will be speaking on this item. Thank you.
Oh, hi, Ms. Munoz. Nice to see you.
Nice to see you as well, Madam Chair. The Department of Finance has nothing to add beyond our written comments. Finance also wishes to defer to the water boards for further comments on this matter. Thank you.
Great, thank you very much. We'll move now to Ms. Fortis and Ms. Hagan for the State Water Resources Control Board and San Diego Regional Water Quality Control Board. Do you have any comments?
Yes, thank you, Chair Miller. I misspoke earlier in indicating which item we had comments on. My name is Catherine Hagan. I'm with the State Water Board's Office of Chief Counsel. And my brief comments today are on behalf of the State Water Board and the San Diego Water Board. And as you know, Jennifer Fortis, Assistant Chief Counsel, is here with me as well. The water boards appreciate and want to recognize the exhaustive work by the commission staff in developing the proposed decision you're considering today. We agree with a significant number of the conclusions and recommendations in the proposed decision. While we continue to disagree with some of the proposed conclusions, we have already expressed those comments in our written comments, and so don't intend to reiterate those today. So that concludes our comments today, but we're happy to answer any questions if the commissioners have any.
Great, thank you very much.
Thank you.
We'll now move to public comments on this item. Are there any public comments? Anyone wishing to comment for any reason? You could just raise your Zoom hand. Seeing none, I'll turn it back to the committee and see if there's any questions from members. Seeing none. I will then, any further discussion for any reason? No, okay, I'll then entertain a motion, please.
I move to adopt the proposed decision.
Thank you, Mr. Walker. Do we have a
Seconded.
second? Thank you, Ms. Olson. The staff recommendation was moved by Mr. Walker, seconded by Ms. Olson. And we will now call the roll, please.
Mr. Adams,
Aye.
Ms. Evans, Ms. Holman,
Aye.
Ms. Miller,
Aye.
Ms. Olson,
Aye.
Mr. Walker.
Aye.
Great, that the motion carries. We will now move to item 4, Ms. Halsey.
Item 4 was postponed at the request of claimants. Next is item 5. Commission Counsel Anna Barrett will please turn on her video and unmute her microphone and present her first proposed decision on sex offenders registration petitions for termination 21 TC03. At this time, we invite the parties and witnesses for item 5 to please turn on their video and unmute their microphones.
Great, thank you very much. May we please start with Ms. Bark, please, go ahead.
Thank you.
Could you speak up just a little bit? I'm having a hard time hearing you.
I'm sorry about that. Let me see if I can do something
That's great.
about it.
That's perfect. That's
All
better
right.
already. Great.
All right. Good morning, everyone. This test claim involves a major change to how California's sex offender registry operates. Under prior law, all convicted sex offenders living in California had a duty to register with their local law enforcement agency for life. Failure to register in accordance with the law is a crime punishable as either a misdemeanor or felony, depending on the defendant's original offense. The test claim statute created a 3-tiered system for classifying sex offenders, where each tier has a minimum mandatory registration period as low as 10 years. After a sex offender completes their minimum registration period, They may petition their local court to relieve their duty to register and serve the petition on the county's law enforcement agency and district attorney's office. The court will hold a hearing if the district attorney challenges the petition. Although the test claim statute created mandatory activities for law enforcement agencies and district attorneys, staff finds costs mandated by the state because the test eliminated a crime or infraction.
I'm sorry, Miss Barrick, this is the court reporter. At least on my end, your audio broke up a little bit, and I'm not sure if I missed some words or not. So do you want to start with although the test claim statute created? Can you start there?
I would be happy to.
Oh, I think you're cutting out again, Miss Barrick. So I think when you held the microphone closer to you.
I'm also getting a notification that my connection's a little unstable, so.
So I think what you want to do is turn your video off, actually.
I could do that, of
Great.
course.
And then just hold the microphone closer. There you go. Let's try it again, starting with although the test claim.
Although the test claim statute created.
Okay, so whatever you're doing right now, I think it's easier to hear. Although the test claim statute
created mandated activities for law enforcement agencies and district attorneys, staff finds there are no costs mandated by the state because the test claim statute eliminated a crime or infraction pursuant to Government Code Section 17556G. Once the duty to register is terminated, the offender is no longer subject to the requirements of the Sex Offender Registration Act, and any criminal penalties for failing to register or to otherwise comply for life are eliminated. Accordingly, staff recommends that the Commission adopt the proposed decision to deny the test claim and authorize staff to make any technical, non-substantive changes following the hearing. Thank you.
Great, thank you very much. I'm just checking with the court reporter. Are you good now?
Yes, that was perfect. Thank you.
Great, thank you very much. And if Ms. Bark, if you want to turn your video on just so we can see you. If we have questions, we'll see if your internet stabilizes. Thank you. Never a dull moment with technology, right? So now we'll move to the parties and witnesses. And as you're testifying, please feel free to let us know if you need anything clarified. Mr. Lemus, Ms. Gonzalez, and Mr. Ford for the claimants. If you'd like to begin, please.
Sure. Good morning. My name is Fernando Lemus. I am the claimant representative for the County of Los Angeles. I'm here to introduce Lucia Gonzalez and Mr. Dylan Ford from our Office of County Counsel. I'm going to turn it over to Lucia so she can begin with her comments.
Thank you, Mr. Lemos. Good morning, everybody.
If you could state your name one more time for our court reporter, please.
Yes, thank you. My name is Lucia Gonzalez with the Office of County Counsel. The proposed decision concedes that SB 384 imposes state mandated activities on the LA County DA's office and Sheriff's Department, but not the Public Defender's Office. In a moment, my colleague Dylan Ford will describe the Public Defender's instrumental role in this program, by which the legislature's intent for passing SB 384 would be thwarted without the role of the PD's office in assisting petitioners. But before we get to that, the big issue here is, does the government code exempt reimbursement to the county? Because the staff commission's decision already concedes that there are state mandated activities. So the question is there an exemption that prevents the county from being reimbursed for this very involved program? The county urges the commission to find that Government Code Section 1755G does not apply here. I'd like to read into the record Government Code Section 1755G. Government Code Section 1755G, the commission shall not find costs mandated by the state in any claim where the statute created a new crime or infraction, eliminated a crime or infraction, or changed the penalty for a crime or infraction, but only for that portion of the statute related to the enforcement of the crime or infraction. Staff agrees that SB 384 did not change the penalty of a crime, and they agree because the U.S. Supreme Court and the state Supreme Court and the lower courts have all agreed that the act of registration is non-punitive. It is regulatory in nature. So therefore, SB 384 cannot be considered a change in penalty of a crime. So the next exemption that the staff urges this commission to adopt is, well, then a crime must have been eliminated. While they argue this, staff has failed to indicate what crime has been eliminated. There is no crime that has been eliminated here. SB 384 has always been a regular, or the sexual registration requirement has always been regulatory in nature. What SB 384 did was to modify the registration process. And my colleague, Dylan Ford, will speak about the registration requirement, the legislative intent of 384. Mr. Ford is currently a county council attorney for LA County. However, he is a 17-year veteran of the Public Defender's Office for LA County and previously led the effort in the SB 384 program at that office. So I will turn it over to Mr. Ford.
Great, thank you. Hi, Mr. Ford. If you could state your name for the record as well, please.
Good morning, Madam Chair. Dylan Ford from the Office of County Counsel for Los Angeles County. And just by way of background with SB 384, this statute, originally, I believe, sponsored by the LA District Attorney, was not necessarily an effort on behalf of sex offenders at the time, but rather the intent was to actually aid law enforcement agencies who were dealing at the time with a tremendously unwieldy number of registrants. The way that the criminal law expanded to cover more and more offenses that triggered the registration requirement led to a huge explosion in the number of registrants within California. As of November 2022, there were more than approximately 80,000 sex offender registrants living within the community and about 14,500 living within Los Angeles County. And what was happening is that the original intent of the registration requirement was actually being undercut because rather than allow law enforcement agencies to surveil people who are at high risk of reoffense, instead they were spending all of their time going through basically the administrative role of just basically receiving registrations by the people who live within the community. The idea was to pare down the registration list so that law enforcement agencies would be empowered and have more time and greater resources to surveil those most at risk of committing new offenses within the community. Once that the statute was actually passed, at least in LA County, there was a tremendous effort to try to receive all of the requests for assistance from the people who could benefit by this law. And what has happened as a practical matter is that with this new law, district attorneys' offices, the courts, the clerks of the courts, law enforcement agencies were all completely unfamiliar with the process. And their default answer when presented with a registrant who wanted to seek relief under the statute was to refer them to the public defender's office. And we received, and actually at the time I was leading the effort for the LA County Public Defender's Office, or I was the point person. So I would receive calls from clerks of the court. We had many meetings with the court, the DA, and other stakeholders, and from law enforcement agencies themselves who didn't know exactly how this law operated, what was the proper manner of petitioning, and needed assistance in getting these petitions filed and filed properly, including the proof of service that's required under the statute. Pro per petitioners also had difficulty, even though the petition itself is not difficult to complete. The rules of service, where to file, etc., and particularly if the case actually went forward to hearing, having the presentation at a hearing involved a complex analysis of risks to community safety that were implicated by the statute. All that is to say that this required a tremendous amount of resources on the part of the public defender to answer the calls of all these various stakeholders. And it created, as in sort of like the language that the staff applied to the district attorney's office, while the public defender was not named particularly in the statute, it did as a practical matter constrain the public defender by its duty to its other stakeholders in the criminal justice system and to these pro per petitioners to have the statute operate in the way that the legislature intended. And just to be clear, the statute did not eliminate 290.018, basically the penalty statute within the sex offender scheme. Rather, what it did is provide an avenue for people to no longer to be subject to that scheme. And the important thing to remember is that these are folks who the only way they can actually be entitled to relief is if they in fact register faithfully. If they register every year, if they register upon any move, if they move residences, if they register, if they go to a university or visit a school, they have to register with the authorities there. Although only those people who register all the time and never fail to register are those who are eligible for relief from the duty to register. So these are not the population of people who would be charged hypothetically with a failure to register at some future point. Rather, this particular population is entitled to relief precisely because they always register faithfully. And essentially what the legislature has provided and mandated is an effort to try to relieve law enforcement agencies of a duty to register these people who've been registering for decades faithfully in many cases, and allow them to focus their resources only and to surveil and monitor those people who are at a high risk of reoffending within the community.
Thank you, Mr. Ford. Mr. Ford, can you speak about whether SB 384 creates an affirmative or an automatic removal from the registry, and also how this statute is distinguished by the youth offender parole statute and that decision?
Yes, I mean, with regard to the youthful offender parole hearing statutory scheme, as discussed in the case cited by the staff, that created a situation where by operation of law, youthful offenders were guaranteed an earlier eligibility date. Again, this has to do with people who are serving prison sentences and become eligible for parole. Obviously, incarceration and parole are both classic punishments under the system, whereas registration is a mere regulatory function that is not within the continuum of state-imposed punishments. That basically operation of law is critical to that decision because it applied to the entire class of youthful offenders, and no matter what their case was, no matter their comportment during their time incarcerated, they would be given the benefit of an earlier parole eligibility date. By contrast, we're talking about for SB 384, we're talking about a system that does not involve a penalty. You know, the registration requirement is not a penalty. And furthermore, nothing is triggered by mere operation of law. There are other states that have sex offender systems where if you register for 10 years, automatically you are relieved of the duty to register. By contrast, in California in SB 384, there is an affirmative duty, not only to register faithfully and avoid any new criminal conviction, but also affirmatively petition the Superior Court in order to seek relief. So in these particular areas, you have key distinctions with the youthful offender parole hearing decision, and that we are not talking about penalty, we are not talking about classic punishment, and we're also talking about, in the SB 384 context, only those who affirmatively establish their earning of the relief of the duty to register that are affected by the law. Nothing happens automatically. And to emphasize again, these are particularly the people who would not be prosecuted, who would not basically utilize the resources of the county otherwise, precisely because they are only entitled to relief because they are following the law and are not committing crimes. And that is how they effectively get any relief from the Superior Court.
Okay, thank you, Mr. Ford. Aside from the youth offender parole case that the staff cited in their proposed opinion, which is not analogous here, youth offender parole involved the elimination of penalties. We're not talking about penalties here. It's clear that registration is not a penalty. They also cite two test claims. They also concede that the findings of this commission with former test claims is not precedential. However, I'd like to comment on the test claims that were referenced by the staff in their proposed decision. The accomplice liability test claim, where the commission held that the county was exempt from reimbursement because that test claim statute eliminated the felony murder rule from being applied and used in criminal prosecutions. Again, there has been no indication of any type of criminal theory or rule or crime that has been eliminated by 384. That test claim is not analogous to the facts here. They also cite a test claim 97 TC 15. That test claim actually added crimes added sex crimes that would trigger the registration requirement. Clearly, that's very different than what we have here. In that test claim, crimes were added. Again, no crimes have been added here. No crimes have been eliminated here. On page 44 of its proposed decision, the staff commission writes, under prior law, the requirement to register annually and at any time the offender moved existed for life. But the test claim statute eliminates the requirement for a sex offender to register under the act once the offender successfully petitioned to terminate their duty to register. We wholeheartedly agree with the staff in that statement. The test claim statute eliminates the requirement for a sex offender to register once they successfully petition to terminate. Again, no crime has been eliminated. No crime has been added. The requirement to register goes away if a petitioner were to, if a sex offender were to petition. If a sex offender never petitions, they're never off the registry. They stay. We believe that the staff commission's broad interpretation of Government Code Section 17556G would relieve the state of its constitutional obligation to reimburse the County of Los Angeles. This would be an impermissible use of Government Code Section 17556G. It would be impermissibly broad, the county believes, for this commission to apply this exemption to the facts at hand. And we ask that the commission reconsider the proposed decision of the staff and find that costs have been mandated here by the state on the county. There is a program in place. The public defenders are actively involved in this program, although they are not specifically referenced in the statute, and that there is no exemption here. No penalty has been eliminated, and no crime has been eliminated. No crime has been added. Thank you.
Thank you very much. We really appreciate it. We'll now move to Mr. Hill, please, for the Department of Finance.
Good morning, Chris Hill, the Department of Finance. I can just say the Department of Finance concurs with the commission staff's recommendation on this test claim.
Great, thank you very much. Is there any public comment on this item? Anyone wishing? Did someone wish to comment? No. Anyone wishing to comment for any reason, please raise your Zoom hand. Seeing none, we'll now turn it back to the commission. Are there any questions from the commission? Yes, Ms. Olson.
I just want to say that I find the arguments of LA County to be really compelling, and I would like a response from our attorneys.
Great, thank you very much. I'm going to see if we can, maybe if there's questions for our attorneys from Mr. Adams. Was that a similar question, Mr. Adams, just for our team to respond?
Yes, and then I have some additional questions after that, or comments. Thanks.
Great, thank you very much. Ms. Holman, is this a question specifically for our attorneys so that they can respond to LA County?
No, it was
no, it's separate. Great, okay, so if you want to go ahead and mute, then we'll go to Ms. Barrick and Ms. Shelton to respond to the positions from LA County. And if your internet is still unstable, please feel free to go off camera again.
Please warn me if you're noticing any more audio issues with me. All right, so I've been taking notes on what Mr. Ford had to say, and when he pointed out that the intent of the law is to aid law agencies in paring down registration, yes, what they've done is in doing so is by making it no longer a crime for these people to stop registering as sex offenders. That's how they've pared down the sex offender registration list. And for the simple question of what crime has been eliminated, it's the failure to register with respect to people who have terminated their duty to register. As for the people who have been seeking assistance.
Sorry, I don't know if everyone else could hear that. It's the failure to what that?
It's the failure to register with respect to people who have successfully terminated their duty to register. So they previously they had a duty to register for life, and so they would have been guilty of a crime if they failed to register. Now they are no longer guilty. Now the crime of failing to register has been eliminated with respect to these people.
And so we're talking about Penal Code Section 290.018, which makes it a misdemeanor or felony to failure to register. So just to clarify.
Thank you.
As for the influx of people that the county has had to deal with seeking assistance, that the public defenders have had to deal with seeking assistance for these petitions, it's admirable that the public defenders have been doing what they can to help them, but the state has not mandated that they perform this activity. As for, I will consider that the point Dylan Ford raised about being practically compelled is something that that was not previously raised by and we have not previously analyzed it, but the stance that the test claim statute does not eliminate Penal Code Section 290.0018 because the people that are entitled to relief have always followed their duty to register. As a result of the test claim statute, they are able to end that obligation. And the final point that I have in my notes is that for the argument that youth offender parole hearings is different because it guaranteed parole hearings for these people, the test claim statute entitles Tier 1 and Tier 2 sex offenders to hearings on whether or not to terminate their duty to register.
Great, thank you, Ms. Bark, and I'm so sorry for this internet issue. Did the court reporter get all of that? And then I'm going to turn it to Ms. Shelton.
Yes.
Great, thank you. Ms. Shelton, and then we'll turn it back to Ms. Olson, please.
Just a couple of things. One on the issue of the public defender. We have had post-conviction test claims in the past where those statutes have specifically imposed duties on public defenders, because typically under the law, there's no guarantee to the right to counsel unless your liberty is being affected. So in this case, the legislature did not specifically address the public defender. We find no duty or a mandate imposed on the public defender with these statutes. And so without any substantial evidence in the record to show certain and severe consequences, the commission cannot make a finding of practical compulsion with respect to the public defender's office. Secondly, the County of San Diego versus Commission on State Mandates case dealing with a youth offender parole hearing. The court made some very clear statements with respect to 17556G overall. One, that the statutes, even though the test claim statutes don't vacate crimes or vacate sentences, they did affect the overall penalty in that case for those individuals. Here, the same is true. Although the test claim statute does not eliminate any crime itself, you have to apply the rules of statutory construction and determine the effect of that particular statute. In addition to the test claim statute, you had Penal Code Section 290.5, which said you have a duty to register unless you get a petition filed under the test claim statute. So as Anna mentioned, that once that duty to register is terminated, the offender is no longer subject to the requirements of the Sex Offender Registration Act. And any criminal penalties under Penal Code 290.018 for failing to register or otherwise comply for life are just eliminated. And so, yes, we do believe 17556G applies.
Great, thank you. Ms. Olson, do you want to follow up?
Yeah,
Sorry, could I realized one more thing that I wanted to add just in response to Lucia's comments about the previous commission decisions, particularly the one involving the previous sex offender registry cases. She is pointing out that the test claim that previous test claim statute added new crimes. It wasn't just that they added new. The argument at that time wasn't that they added new crimes. It was that existing crimes that already existed were added to the list of crimes that could be registered, that must be registered as, that require someone to be registered as a sex offender. And in making that change, they had created a new crime with respect to Penal Code 2.0018. That was what happened with the previous test claim.
Ms. Barrett, state the penal code number again. I'm not sure I got every number.
290.0018.
Okay, go on.
Yeah, so just like how that previous test claim had added new crimes, this has eliminated a crime by making it possible for people to no longer have a duty to register.
Right, and did the court reporter get the penal code number? It cut out for me.
Yeah, I had her restate it. Thank you.
Great, okay. Great, Ms. Olson?
Okay, so just to follow up here, I guess what I'm finding difficult here is that Ms. Gonzalez and Mr. Ford's testimony, I think, makes a compelling case that the elimination of the crime doesn't happen, as I understand it, until a regulatory process takes place. And that's what I'm finding compelling about the county's point of view here, is that they still have to register until they do this other thing, which is a regulatory process. And so the elimination of the crime follows the regulation. And that's what I'm finding compelling.
It's not a regulatory process. They have to file a petition for termination, which goes to court. You have criminal attorneys representing the state, and you're going back to the criminal court if there's a hearing. It's the function of regulation. It's the function of registering a sex offender that is regulatory, but there is a criminal penalty for failing to do that. And it goes back to the criminal court on the petition.
And what
Wait, hold on one second, because we can barely hear you, Ms. Spark. I know this isn't your fault, but Ms. Olson, did you want to follow up on that? This distinction between a regulation? Oh, you're muted, Ms.
I'm happy to listen.
Okay, great. Ms. Spark, go ahead if you could just speak up a little bit.
So what this is what they've created is a procedure for terminating someone's duty to register, an ability that never previously existed. It was there, if someone had a duty to register as a sex offender, that duty existed for life. Now they have this procedure where they can petition the courts, and they will hold hearings as necessary to determine whether or not to grant that petition. And the court in the County of San Diego case, the youth offender parole hearing case, found that when that procedural and administrative tasks can still perform of eliminating a crime, of changing the penalties for a crime by guaranteeing parole eligibility for all qualified youth offenders. The test claim statute had altered the substantive punishments in this case by creating a procedure where petitioners are able to seek the ability to terminate their duty to register. They've altered the duties and made it possible to eliminate this crime.
Great. I'm gonna hold it before we go to the witnesses. I'm gonna go to the commission. Ms. Olson, are you satisfied with those answers? Any follow-up questions? Great. Thank you. Thank you for those questions. Mr. Adams and then Ms. Holman, please.
Thank you, Madam Chair. Like Ms. Olson, I'm having a tough time with some of this. I see it as a new program, an additional level of service. It appears to be mandatory on local agencies. They don't have any fee recovery. I also don't see it as a decreased penalty, but a regulatory scheme. I also don't understand the logic that it eliminates a crime. It doesn't eliminate Section 290, but it just eliminates when Section 290 can be charged to a defendant. And again, while the legislature doesn't necessarily direct anybody to do anything, it does put in motion a mandatory obligation for at least the district attorney and law enforcement. I'll remain silent on the public defenders, although it would be interesting to know if the courts are requiring them to get involved. So I'm having a real tough time supporting the recommendation before us. I don't see it eliminating a crime at all, just when a new crime be alleged against a defendant who fails to register in the future. So again, I see this obligating local government to do something that they cannot escape, at least for the DA and the sheriff.
Staff's
stance
on that is still that by creating this to terminate their duty to register, the legislature has eliminated a crime with respect to the people who successfully terminate their duty to register.
And again, I understand that, but in order to eliminate their duty to register, there's an obligation on the part of local agencies to do something that is costing them. So again, I can't get through all of the logic on this, but thank you.
Ms. Shelton, yes, please go ahead.
I don't know if this will help Mr. Adams or not, but on the County of San Diego case, so that was the youth offender parole hearing, and that those statutes themselves and the by operation of law, the Franklin proceedings that they had themselves did not change the penalties. Their sentences were not changed, and the court agreed with that, but said you have to look at this overall. And even though this is an administrative process, ultimately the effect of this was to reduce their sentence and grant them parole, early parole, so that you're not just looking at the statute themselves, you have to look at the effect of the whole thing. And here we've looked at the effect of the whole thing, and so for them it does take away and eliminate the crime of failing to register because it's been terminated, and that's the only point.
Yeah, I mean, that's what I find compelling is the point you just made, that the change is to terminate the lifetime enrollment and then you eliminate the crime. I mean, I do think that's where I disagree that it's a higher level of service. But Ms. Holman, did you have a question here as well? You're mute. Oh.
I think it was answered, but I was just trying to figure out, like, sort of the two questions. One, go to the higher level of service and elimination of the crime. I mean, I know this is San Diego and LA is the one that asked for it, but didn't Mr. Ford, I believe, say like it was asked for to try to reduce criminal non-reporting and the burden, like to focus on like the more egregious criminal non-reporting? And then the second question was, it seemed like most of the costs that were described as incurred were associated with the enactment of a new law and confusion at the court, and not necessarily anything that was mandated by the law. And I was hoping they could speak to that.
Yeah, I mean, I think if we just want to cover that one more time, that would be great. And just to be clear, you want our team, the Commission on State Mandates team, to speak to that, or the LA County?
I was wondering about LA County, but I'd be happy.
Okay, why don't we go ahead and have LA County answer that briefly, and then we'll turn it back to Ms. Bark and Ms. Shelton. I don't know who for LA County wants to answer that. And you're muted.
Okay, yes. So the question is, are there activities imposed on these agencies, the DA's office and the law enforcement, from the passage of this 384? Is it just, does 384 actually create a new program that imposes state mandated activities? Is that the question?
When Mr. Ford was talking about the cost that was the huge burden that they were experiencing, it sounded like more like as a result of the confusion associated with the new law rather than the cost of the program that was mandated by the state.
Okay, so yeah, and that was with regards to the public defender's role. Is there any, do you have any disputes as to whether there were costs mandated on the DAs or law enforcement by the statute?
You mean questions?
Or concerns? I guess I just want to be sure, is it that you would like us to speak about the public defender's role, or?
Well, that was the main thing that you spoke to in terms of like the significant cost. I heard you saying was the public defender's significant costs associated with explaining to the court what the rule, new change in law was, or to.
Okay.
And then as well, like, I was trying to understand, like, I thought he had suggested that this was asked for to reduce costs. And I was trying to understand that.
Well, okay, sure. I'll let Mr. Ford go ahead and handle that then. Thank you, Ms. Holman.
Thank you. I would emphasize that that it is true that adjusting to the new law did include some, basically on the part of all the stakeholders, getting used to it and learning how to do it. But in preparation for this hearing, I spoke with current members of the Public Defender's Office who are still representing these clients and filing petitions and conducting hearings. And it wasn't only the initial confusion and everybody kind of learning how the law operates, but the same pressures from the entire system to effectuate the legislature's intent continue to obtain. It's still the case that courts will refer pro per petitioners to the public defender. Law enforcement agencies will send all of their registrants who they think might be eligible to the public defender's office. District attorneys who receive a non-conforming pro per petition will refer that person to the public defender's office. So again, even though the law now has had some time to sort of basically become part of the system, it remains the case that the public defender is still sort of like the point person to effectuate the legislature's intent. And just if I might expand a little bit, I think this might address the second part of your question, which is that 290.018, the penalty statute, that is being prosecuted in LA County courts all the time. That crime has not gone anywhere. The district attorney, many city attorneys are filing prosecutions throughout this county, and I'm sure every county in California. The difference is that the people who are eligible for the relief under this statute, the crime's not being eliminated for them. What's happening is that they are showing by years of consistent registration that they are eligible for the relief that the legislature intended for the purpose of opening up law enforcement agency resources to focus and monitor and surveil those at high risk of reoffense, rather than spending their time doing the paperwork for someone who's registered since the 1960s faithfully. This group of people who who actually earn relief under the statute, they would never be prosecuted anyway, because they are the ones who register all the time. If they didn't register all the time, they would not get relief. So there is a gap between this idea that you no longer are subject to the registration scheme and that therefore eliminates a crime. That crime is being prosecuted constantly in LA County for those who fail to register. All that's happened is that the county actors here have affected the legislature's intent so that those people who the legislature has determined do not need to register would no longer have that regulatory obligation. It's not that the crime is eliminated, it's just they have been shown to the people for whom the crime was never applicable anyway, because they always register and they do not reoffend.
Right, but I think the distinction here, and I am going to kind of call the question in just a minute. I'd say two things. One, it's very difficult for commissioners to understand intent. So that's just a big distinction here. And then two, we're creating a tiered system like in other states. So we used to have everyone register for life. And then if they moved or failed to re-register, then it resulted in a misdemeanor or felony. And so I do think the potential for the crime, that is for the registration, is what the commission is saying has been eliminated. But with that, any other questions from board members? Any comments from Spark or Ms. Shelton that you'd like to add? No? Okay.
May I just emphasize one last thing?
Very briefly, yeah.
Okay, and that is just to again distinguish between the youth offender parole decision, which involved the changing of a penalty. That's not what we're dealing with here. The staff is urging that this be deemed an elimination of a crime, and also that in that case it involved an automatic termination of parole or early parole, whereas here there's nothing automatic. There is a petition process, and so I think those are two distinctions that I think are important to highlight.
Great, thank you very much. So I think we have a couple options here. We are a small board. I'm happy to move it if there's a second, and I would move the staff's recommendation. Is there a second?
Second.
Great. So I think we have a motion and a second. I know that there's some hesitation here. And another option, Ms. Shelton, I'm going to turn to you here. We have a motion and a second, so we will dispense with this. And then after we take the roll, I think we'll kind of come back to you for some guidance. So the staff recommendation has been moved and seconded, making sure there's no additional public comment. Anyone wishing to comment for any reason? Seeing none, Ms. Halsey, if you could please take the roll on the staff recommendation.
Sure, I was just checking for comment, and I see none. Mr. Adams,
No.
Ms. Evans, Ms. Holman,
Aye.
Ms. Miller,
Aye.
Ms. Olson,
No.
Mr. Walker.
Aye.
So the staff recommendation, it carries 3-2. I do think what I would encourage, just because there were some outstanding questions, Ms. Shelton, if it's okay with you, especially to the questions that Mr. Adams and Ms. Olson were asking at our next meeting, I think just a little bit of supplemental information about the questions around, what is a new crime and what crime was eliminated, I think will be really helpful, just so we have full information for all the commission members, if that's okay with you.
Sure.
Great. And then if there are any other requests from any other board members, just so we have some additional background, just so I think we can provide a little more clarity in that regard for our commission members. Anything else that commission members would like to see ahead of the next meeting? Seeing none, thank you for that. Thank you to LA County. Sincerely appreciate the robust debate and you being here, and the compelling arguments you made. Next, we will turn to item 6.
And item 6 is once again Commission Counsel Anna Barrett, and she will present a proposed decision on resentencing to remove sentencing enhancements 22 TCO2. At this time, we invite the parties and witnesses for item 6 to turn on their video and unmute their microphones.
Welcome back, Ms. Barrett.
Seems like I was just here. All right, then. Good morning, everyone.
So I'm just gonna, oh my goodness, you poor thing. I can't imagine how frustrating this is for you. I'm just gonna make sure our court reporter can hear you. You're very slight.
I can. I think when she first starts talking, the first 5 seconds are quiet, and then it just seems to fix itself.
Oh, great.
So-
Okay, good. For me, it only gets like 70% better, but great. If you
Oh, yeah.
I'll just wait and ask you, are all other commissioners able to hear Ms. Farrick? Great. Okay, go ahead, Ms. Farrick, then.
My best to speak from the diaphragm. Good morning, everyone. This test claim involves 2 newly added penal code sections that gave retroactive effect to 2 prior law that eliminated certain sentence enhancements. The test claim statute requires courts to resentence people whose sentences included the now invalid sentence enhancements by set deadline. Staff claim statute imposes state mandated.
Ms. Barrick, your audio is breaking up now. It's not just quiet, but it is breaking up. So
I'm getting another unstable connection now, so I'll stop my video.
okay, if you want to back up a little bit, the test claim statutes requires courts to
Yes.
resentence people.
Yes,
Start there, please.
I can start from there. The test claim statute requires courts to resentence people whose sentences included the now invalid sentence enhancements by set deadlines. Staff finds that the test claim statute imposes state mandated programs on county correctional administrators, county public defenders, and district attorneys. However, staff cannot find that there are costs mandated by the state because the test claim statute changes the penalty for a crime pursuant to Government Code Section 17556G. The test claim statute's purpose is to reduce the sentences of currently incarcerated people, clearly changing the penalty for their crimes. Mandated activities relate directly to a crime or infraction when they play an indispensable role in the scheme the legislature used to change the penalty for a crime. The mandated activities are all indispensable to the scheme the legislature created for removing the invalid sentence enhancements and resentencing people. The test claim statute therefore reduced the penalty for a crime, and the mandated activities relate directly to the crime. Accordingly, staff recommends that the Commission adopt the proposed decision to deny this test claim and authorize staff to make any technical, non-substantive changes following the hearing. Thank you.
Thank you very much. The parties and witnesses, if you could please state your name for the record.
I believe only finance is appearing on this item.
Great. Mr. Hill, do you have any comments?
Chris Hill, Department of Finance. Department of Finance concurs with the Commission staff's recommendation.
Great. Is there any public comment on this item? Seeing none, any questions from commissioners? Yes, Mr. Adams.
Yeah, I have similar concerns with our previous item. Again, this is requiring local government to do things. It's upping their costs. It's not forever. It's just for these resentenced folks. And again, we're talking about penalties versus enhancements. And this did not change their penalty at all, but it changed an enhancement. So again, I'm having a tough time supporting this as written.
Ms. Shelton?
Actually, it does change their penalty. The statute itself says that after the recall and the resentence, it has to result in a reduced sentence. So it is directly attacking and reducing their sentence and changing the penalty for a crime.
And actually distinguished from the prior matter that we just heard, this matter is very analogous to the youth offender parole hearings, which just was resolved in the courts, which is, I believe, why we are not having testimony from the claimants on this particular matter.
Right. Any other comments? Mr. Adams?
No, I'm good.
Okay. Just making sure there's no additional public comment. Seeing none, what is the?
I'll move adoption of the staff recommendation.
Great, moved by Ms. Olson. I will second. May we please take the roll, Ms. Halsey?
Sure. Mr. Adams?
Aye.
Ms. Evans? Ms. Holman?
Aye.
Ms. Miller?
Aye.
Ms. Olson?
Aye.
Mr. Walker?
Aye.
Great, that motion carries.
We
We
will
will now, oh, sorry, go ahead, Ms. Halsey. That's yours.
We will now ask the presenters for item 7 to please turn off their video and mute their microphones. Item 8 is reserved for county applications for a finding of significant financial distress or SB 1033 applications. No SB 1033 applications have been filed. Next, program analyst Jill McGee will please turn on her video.
Heather, item 7 needs to be called, please.
Sorry.
Oh, sorry, I jumped
yes.
ahead. I'm sorry.
Yes, sorry.
I
No,
got-
no worries.
I
was about to say the same thing, Ms. Shelton. Thank you.
You know what? That was accidental, but maybe I do know the court reporter is going to need a break in about 10 minutes. I don't know if we should do the reports and then take the break and then here's item 7 last. Just an idea.
Sure. Is that okay with
For
everyone?
for the flow of the meeting, I think it might help.
Sure. Is that okay with everyone? I apologize. Mr. Burhood, we're going to go ahead and ask you to turn off your video. We're going to do the last pieces, the reporting pieces of the agenda, and then we'll come back to item 7. I apologize for the inconvenience, sir. I
No,
hope
that's fine, Chair Mill. I would say I have about a 38-second statement to make, but I'm happy to go.
Oh, really? Okay.
with the flow.
Well, In
If
that
that's
case,
the
I-
case, why don't we go to item 7 then, just so Mr. Burhan can have his
Sure,
afternoon?
I thought there might be lengthy testimony on it, but that
No,
being the
ma'am.
case, we'll go forward. Okay, then we now ask next is item 7. Chief Legal Counsel Camille Shelton will please turn on her video and unmute her microphone and present a proposed decision and parameters and guidelines on order number R8 2009-0030, adopted by the Santa Ana Regional Water Quality Control Board 09 TC03. The water boards have informed the commission that they do not intend to testify on this matter. And at this time, we invite the parties and witnesses for item 7 to please turn on the video and unmute their microphones.
Great, thank you. Go ahead, Ms. Shelton. Thank
Yes,
you.
real
Sorry.
quickly, that's okay. These parameters and guidelines address state mandated activities arising from a stormwater permit adopted by the Santa Ana Regional Water Quality Control Board on May 22nd, 2009. The proposed parameters and guidelines identify the activities that the commission already approved in the test claim decision, with a period of reimbursement from June 1st, 2009 through December 31st, 2017. The proposed parameters and guidelines further provide that any funds used that are not the claimant's proceeds of taxes shall be identified and deducted from the reimbursement claim as offsetting revenues. Staff recommends that the commission adopt the proposed decision and parameters and guidelines and authorize staff to make any technical, non-substantive changes to the proposed decision following the hearing. Thank you.
Thank you very much, Mr. Burhan.
Thank you, Chair Miller. I have only one very brief comment to make on behalf of claimants. Again, those claimants are identified in the parameters and guidance. The P's and G's include in sections 1 and 7 a requirement that reimbursement is disallowed for funds that, quote, are not the claimant's proceeds of taxes. As the commission is aware, there has been litigation regarding an incorrect reduction claim involving a Los Angeles County stormwater permit test claim, and whether it is appropriate under the California Constitution to prohibit a subvention of funds that may not be subject to a claimant's appropriation limit. That litigation asserted that such a limitation is contrary to the language of the Constitution and the intent of the voters in adopting Proposition 4. I am not aware at this stage whether a similar issue exists for claimants in this test claim, but in light of these issues, I respectfully request deletion of the phrase, quote, and any other funds that are not the claimant's proceeds of taxes, close quote, from sections 1 and 7 of the P's and G's, and a reference to, quote, local proceeds of taxes, close quote, in section 2. The other limitations on reimbursable funding sources are, of course, appropriate. Thank you.
Thank you. Ms. Shelton, I'm going to have you comment on that, and then I'll turn it to public comment.
Yes, that matter that Mr. Burhan was just raising has gone to court. LA County Superior Court issued a lengthy decision agreeing with the commission's decision. The whole point of reimbursement under Article 13B, Section 6 is to reimburse local agencies for the expenditure of their proceeds of taxes that are subject to the tax and spend limitations of the Constitution. To the extent local government receives fees, assessments, or funds from other local jurisdictions that are not their proceeds of taxes, have not been levied by that particular claimant, they are not entitled to reimbursement. I would not recommend making that change. In fact, it's a boilerplate language that we now contain in all parameters and guidelines.
Thank you for that. Are there any, Mr. Hill for the Department of Finance?
Actually, I think it's me. Hi.
Oh, I'm sorry, Ms. Furby.
That's okay.
Thank you.
Yes, Donna Furby, Department of Finance. Finance believes that the proposed P's and G's are consistent with the test claim, and we would also object to the changes that have been suggested to be made to the boilerplate language. Thank you.
Thank you. Any public comment? Seeing none, again, please raise your Zoom hand if you'd like to make a public comment for any reason. Seeing none, I'll turn it to the commissioners. Any questions?
I move the staff recommendation.
Thank you, Ms. Olson.
I would second.
Great. Moved by Ms. Olson, seconded by Mr. Adams. May we have a roll, please?
Mr. Adams,
Aye.
Ms. Evans, Ms. Holman,
Aye.
Ms. Miller,
Aye.
Ms. Olson,
Miss Olson, you're on mute.
Sorry. Aye.
Thank you. Mr. Walker,
Aye.
Great, that motion carries. We So we will have, I just want to reiterate, I'm hoping that the court reporter can stay. Perhaps we just have probably 5 more minutes, maybe 7.
Yeah, I was thinking if the remaining reports are of average length as they usually are, I'm fine for another 15 minutes and I'll just take my break during the closed session.
Great, thank you. And we do not have a closed session today. I appreciate
Oh,
that.
we do
I
have
mean,
a closed session.
we do have a closed session, sorry. Sorry.
That's okay.
We're all gonna get it together today. I apologize for that. Okay, so Ms. Halsey let us know that we do not have any SB 1033 applications. And so Ms. Halsey, if you want to turn it over to Ms. McGee again, please.
Sure. Program analyst Jill McGee will please turn on her video and microphone and present item 9, the legislative update.
Good morning. The following are the legislative updates since the last time the commission met. September 14th, 2023 was the last day for the legislature to pass bills, and the governor has until October 14th, 2023 to either sign or veto legislation. First, AB 961, state mandates, claims. This substantive spot bill would have changed the minimum mandate reimbursement claim amount from $1,000 to $800, but never received a committee hearing before the House of Origin deadline. Second, SB 544, Bagley-Keene Open Meeting Act, teleconferencing, was amended after the legislative report issued on September 8th, 2023, to define the terms remote location and teleconference and create alternative provisions for public meetings beginning January 1st, 2024. This bill was enrolled on September 15th, 2023, and is awaiting the governor's action. Specifically, the bill was amended to allow meetings by teleconference as newly defined and would require at least one member of the state body to be physically present at each teleconference location, defined for these purposes as a physical location that is accessible to the public and from which members of the public may participate in the meeting. The bill would, under specified circumstances, authorize a member of the state body to participate from a remote location, which would not be required to be accessible to the public and which the bill would prohibit the notice and agenda from disclosing. Specifically, the bill would authorize a member's remote participation if the other members who are physically present at the same teleconference location constitute a majority of the state body. The bill would also authorize a member's remote participation if the member has a need related to a disability and notifies the state body as specified. Under the provisions of the bill, that member would be counted toward the majority of members required to be physically present at the same teleconference location. The bill would require a member who participates from a remote location to disclose whether any other individuals 18 years of age or older are present in the room at the remote location with the member and the general nature of the member's relationship with those individuals. This bill would require the members of the state body to visibly appear on camera during the open portion of a meeting that is publicly accessible via the internet or other online platform, unless the appearance would be technologically impracticable as specified. The bill would require a member who does not appear on camera due to challenges with internet connectivity to announce the reason for their non-appearance when they turn off their camera. This bill would also require the state body to provide a means by which the public may remotely hear audio of the meeting, remotely observe the meeting, remotely address the state body, or attend the meeting by providing on the posted agenda a teleconference telephone number, an internet website, or other online platform, and a physical address for each teleconference location. The bill would require the telephonic or online means provided to the public to access the meeting to be equivalent to the telephonic or online means provided to a member of the state body participating remotely. The bill would require any notice required by the Act to specify the applicable teleconference telephone number, internet website, or other online platform, and physical address of each teleconference location, as well as any other information indicating how the public can access the meeting remotely and in person. If the state body allows members of the public to observe and address the meeting telephonically or otherwise electronically, the bill would require the state body to implement and advertise as prescribed a procedure for receiving and swiftly resolving requests for reasonable modification or accommodation from individuals with disabilities as specified. The bill would impose requirements consistent with the above described existing law provisions, including a requirement that the agenda provide an opportunity for members of the public to address the state body directly as specified. The bill would entitle members of the public to exercise their right to directly address the state body during the teleconferenced meeting without being required to submit public comments before the meeting or in writing. This bill would also remove the roll call vote requirement and the requirement for a quorum in attendance at the primary physical meeting location. The bill instead would require at least one staff member of the state body to be present at the primary physical meeting location. These provisions would sunset on January 1st, 2026. Third, AB 143, state government, did not pass by the last day of the session. And fourth, SB 143, state government, was signed by the governor and chaptered on September 13th, 2023. Among other things, this budget trailer bill reinstated the prior authorization, subject to specified notice and accessibility requirements for a state body, to hold public meetings through teleconferencing, such as via Zoom, and suspended certain requirements of the act and would sunset on December 31st, 2023. Staff will continue to monitor for the governor's actions. Thank you.
Great. Thank you very much, Ms. McGee. Is that the end of your report? Great. Thank you very much. Ms. Halsey, we just lost you, so I'm going to go ahead and turn to Ms. Shelton now, please, for the chief legal counsel report, please.
Yes, real quickly, we have no new filings and our litigation calendar is currently empty. So we do just have one recent decision, which is the decision that was discussed in item 7. It was a decision by the Los Angeles County Superior Court affirming the commission's decision on incorrect reduction claims dealing with a municipal stormwater case. There, the claimants challenged the controller's finding that the use of Proposition A and Proposition C local return program funds for the program are not the claimant's proceeds of taxes and were required to be identified as offsetting revenues or are not eligible for reimbursement. The trial court affirmed the commission's decision, fully agreeing with the findings of the commission, and denied the petition for writ of mandate. And that's all I've got.
Great, thank you very much. We have just a couple more for the court reporter for Catherine. We're going to go to the executive director report briefly, and then we will move to the 2024 hearing calendar before recessing into closed session, just so you know what's next. Ms. Halsey, on the executive director report, please.
Hi, yes, since our last commission meeting, our former assistant executive director Heidi Palchuk has left the commission for a promotion at the Office of Emergency Services, and we have hired 2 new staff members of the commission. Joseph Ortiz, please turn your camera and unmute your microphone. Joe is our information technology specialist 1. He graduated magna cum laude from Arizona State University, earning a BA in interdisciplinary studies with a minor in IT. And in addition to his degree, he's obtained several IT certifications. Mr. Ortiz has worked in IT for state and local government agencies since 2017, including the state's Office of Systems Integration, Nevada County, and most recently the city of Roseville.
Congratulations. We're thrilled to have you join us.
Thank you. And he just started with us a little over a month ago, and we are delighted to have him.
Great. Thank you very much. Welcome. And I just want to thank Ms. Palchuk for her service to the commission. Wish her well at OES. And please, 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 I don't imagine she's on camera, but it would be wonderful just to get to honor her and acknowledge her service for all these years at the commission. So thank you and all the very best to Ms. Polchek. Anything else, Ms. Halsey?
Also, just to announce our new Assistant Executive Director, Administrative Services, Christina Bardasu, will begin working with the commission on Monday. So everyone will get an opportunity to meet her in October.
Great. Thank you very much. That's great news. And again, all the best to Ms. Polchek.
Okay. I do have an action item on, so we'll get to that. And this is the proposed 2024 hearing calendar. The commission meetings are usually held on the fourth Fridays of odd months unless they conflict with a holiday. In 2024, there are no holiday conflicts with the commission's regular hearing dates, though the May hearing is proposed for Friday of Memorial Day weekend, as is usual. Therefore, all 2024 regular meetings are proposed for the fourth Fridays of odd months. In addition, tentative hearing dates are proposed for April 26, 2024 and October 25th, 2024. Staff recommends that the commission adopt the proposed 2024 hearing calendar.
Right. Thank you. Any questions on the calendar?
I would so- I
Great.
would second.
Ms. Olson, seconded by Mr. Adams. Any public comment on the calendar? Seeing none, may we take a roll call on the calendar, please?
Mr. Adams?
Aye.
Ms. Holman?
Aye.
Ms. Miller?
Aye.
Ms. Olson?
Aye.
Mr. Walker?
Aye.
Great, thank you. The 2024 calendar is approved. And we will now move into closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission will also confer on personnel matters pursuant to Government Code Section 11126A1, and we will reconvene an open session on this link in approximately 15 minutes or less. So please be ready to come back. And then if the commissioners are also, like I, having a hard time finding the closed session Zoom hearing, it was sent by Ms. Halsey.
And I just resent it to everybody.
And she just resent it. So if anyone's having a difficult time like I was, please just refer to the email that Ms. Halsey just sent. And with that, we will adjourn into closed session and be back in less than 15 minutes. Thank you. We'll just give, do we need a quorum, Ms. Halsey, in order to adjourn? You're on mute.
Yes, we do. We should have one in a second, I hope.
Is the
We-
court reporter still on her break?
No, she's.
No,
looks
I'm here.
Great, thank you so
Yeah,
much.
we have a quorum.
Oh, great,
I believe.
thank you. Great, thank you, everyone, and thank you for your patience this morning. The commission met in closed session, closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission also conferred on personnel matters pursuant to Government Code Section 11126A1. With huge gratitude for Ms. Palchuk for her service, and as always, the Commission on State Mandates team. I do just want to acknowledge Ms. Varick, as this was her first time testifying under challenging technological circumstances, and you did a fantastic job. So just grateful to have you on the team, and thank you for sticking through those issues. And with that, unless anyone has any further kudos, I will entertain a motion to adjourn.
So moved.
Moved by Ms. Olson,
Second.
seconded by Mr. Walker. And I think we have to call the roll to adjourn here.
Sure.
Every board is
Ms.
different. Thank you.
Mr. Adams,
Aye.
Ms. Evans, Ms. Holman,
Aye.
Ms. Miller,
Aye.
Ms. Olson,
Aye.
Mr. Walker.
Aye.
Great. Commission on State Mandates is adjourned. Thank you. Thank you. Thank you again. Have a great weekend, everyone. Take care. Bye-bye.